So, hello and welcome everyone. Today we are going to take a look at a decision of the Unified Patent Court, the UPC, and this is more specifically a decision of the Munich local division of the UPC. This is a case where the UPC decided on an SEP front case, actually for the second time ever, after the launch of the court in 2023. The first ruling was delivered by another local division of the UPC, which was the Mannheim local division, and it was delivered a couple of weeks before this one here. We have already discussed the previous decision. It was a case between Panasonic and Oppo in one of our previous webinars. Today we are going to take a look at the second decision, which the UPC has delivered on an SEP case. And here we are going to, among other things, try to identify which of the questions the court has answered in a similar way, where we had some discrepancies between the local divisions. And then maybe at the end, we will try to have a first takeaway of how these first decisions of the UPC give us a good impression of how the court, this new court, intends to work with front and SEP cases in the future. So this is a case between Huawei, who had the claimant's role in these proceedings, and Netgear, who was the defendant. As always, let's take a quick look through the background of the case. It was a dispute which involved a patent relevant for the Wi-Fi 6 standard. So we're not in the cellular sphere. We are working with the Wi-Fi standard. And respectively, this means that the front undertaking that was given here by the patent owner, by Huawei, was a front undertaking towards IEEE. It was a letter of assurance that Huawei submitted in 2019 regarding this patent. Almost a year after that, Huawei contacted Netgear for the first time about its Wi-Fi 6 portfolio, and invited Netgear to start negotiations for a license. As far as we can understand, initially there was not much participation on Netgear's side, but nevertheless, throughout the discussions of the parties, Huawei made 3 offers for a bilateral license. And what was interesting in this case as well was that there was a second option offered, in a sense, by Huawei, which was to Netgear taking a license to the CISVL pool of covering Wi-Fi 6 technology. So these were 2 options here, and we're going to see how the court dealt with this later on. Now, there was, apart from these offers made, there was no agreement between the parties. So at the end of the day, Huawei filed this lawsuit before the UPC Munich local division in June 2023. That was almost simultaneously after the court started its operations in the same month. Maybe just here for information, before that, there had been also cases filed by Huawei in Germany before the national courts. I think in this case it was the local, the district court of Düsseldorf, which had been also involved in these proceedings. At some point during the proceedings, Netgear countered and filed a lawsuit against Huawei in California in the US, based on antitrust considerations, basically. And there was also a motion to grant an anti-suit injunction that would impact the UPC proceedings. There was a reaction on that by Huawei, which asked the UPC to grant an anti-suit injunction that was actually granted in December 2024. And almost a week later, the UPC also delivered its decision in these proceedings. And this was a decision which was favorable to Huawei. The court found mostly in favor of Huawei, and among the other remedies, it also granted an injunction against Netgear, which would have effect in 6 member states of the UPC, which would be in the present case Belgium, Germany, Italy, Finland, France, and Sweden. After that, there had, at least as far as we can see, there have been no further developments in these proceedings. There is no appeal proceedings so far. And probably the reason for that is that in January 2025, a couple of weeks after this injunction, the decision was delivered by the UPC, Netgear announced that it took a Wi-Fi license from the Sysvel pool. This means that probably we will not have any more decisions coming out of this dispute here, and we will unlikely have also an appeal decision. So this is a very brief summary of what happened here in these proceedings. And let's now turn to the legal findings, to the legal reasoning of the court. There were here in these proceedings several layers of defense that Netgear had produced towards the court. We are going to focus on the front specific elements. So we're going to focus on the front defense that Netgear raised here. We're going also to take a look at some arguments that have been raised based on proportionality, and also some arguments based on the letter of assurance under the IEEE bylaws that Huawei had made here, and whether this includes an injunction ban or not, or a litigation ban or not. But apart from that, just for us to have a more complete picture, there were other two big elements which were discussed by the court here, which unfortunately we cannot go into the details. But just to have a complete picture, there was a significant discussion around the jurisdiction of the UPC, which was owed to the fact that Huawei had initially opted out the patent in suit here from the jurisdiction of the UPC, meaning that it had made a declaration that it does not wish the UPC to have jurisdiction over this patent. Then this was withdrawn, and there was a debate in the proceedings whether the court could assume jurisdiction over the infringement of this patent, because there was an unclarity of whether this withdrawal was valid or not. The court at the end of the day decided that the withdrawal was okay, so that jurisdiction could be taken for this patent. So this was one element, the jurisdiction. And the other one was an argument based on a potential exhaustion of the patent rights. And here, the argument was basically that there was an agreement between a license agreement between Huawei and Qualcomm, who was one of the suppliers of modems to Netgear. And basically, based on this agreement, Huawei was prevented from asserting patents, the same patents against Netgear, because they were covered, to put it very simple, by the license that Huawei and Qualcomm had signed. So this argument was in part successful, because the court saw that indeed there was an issue there. It did not lead, however, to the court dismissing the whole action, because Netgear had also products in the market which used modems of other suppliers, MediaTek and Broadcom, for example, for which there was no issue with an agreement, with a license between Huawei and these other suppliers. So this very quickly, just for us to have a full picture of how the case was argued here in these proceedings. And let's turn now to the more front-related topics. And we'll start with the first one. I mentioned that already. The question whether the IEEE LOA that Huawei had made here prevented Huawei from seeking an injunction in these proceedings. And the answer that the court provided here was no, that this is not the case. The topic was more or less how to interpret this LOA that Huawei had given towards IEEE. And here we need to have a bit of a background. There was a policy, the IEEE bylaws and IPR policy, which provides how to deal with patents and other IPRs related to the standardization efforts at IEEE. And there was a 2007 version of these bylaws, which did not include specific restrictions or great restrictions regarding litigation, and especially seeking injunctions based on patents that have been declared or covered by LOAs given towards IEEE. There was, however, later on in 2015, a reform of these IEEE bylaws, which had some restrictions introduced in these later versions regarding whether you can have claims for injunctive relief based on patents that are covered by an LOA given to IEEE. And the argument here was that this version also applied for the IEEE LOA that Huawei had given here, so that a litigation ban or at least restrictions were in place as far as the enforcement of the patents, as far as what Huawei could ask basically in enforcing its patents that are covered by the LOA. Now, the court said that the LOA which Huawei submitted was based on the 2007 IEEE bylaws, which did not include a litigation ban, and it did not see any grounds how to argue that the later versions of the bylaws, which had some limitations, would apply to Huawei's LOA, because it was clear that Huawei did not submit an LOA under the later version of the 2015 IEEE bylaws. And there was also not, at least in the eyes of the court here, convincing arguments to say that these restrictions applied to the previous, to LOAs given under the previous policy. So the court looked at the IEEE bylaws itself. It said there is no provision really saying that you have this mechanism that the new version of the bylaws applies also to existing LOAs. So this is neither Section 8 or any other provision of the bylaws. And apart from that, the court also noted here that Netgear did not claim that the applicable law, which in our case here is the contract law of the state of New York, includes a respective provision that you could argue that the revision of the bylaws would apply to LOAs that have been given under a previous version of the bylaws. So that was the court's analysis here, and this argument was dismissed. So the court did not see that, based on the IEEE LOA that Huawei had given, it was prevented from seeking injunctive relief in the present case. Then the court looked at the front defense, which Netgear had raised here, and this was, of course, a major part of the decision of the court. What is interesting here is that we had two different angles under which this front defense was raised. So we had, on the one hand, a competition law angle. Here, to put it very simple, the argument was that by filing this action, this lawsuit here, which included a claim for injunction and destruction of products, so exclusionary claims, Huawei had abused the market dominant position, so that this claim should not be granted. And there was a second aspect, which was a contract law base of the front defense. Here, again, in simple terms, we're going to take a look at that more in detail in a moment. The argument was that the way Huawei behaved did violate its obligations, contractual obligations towards IEEE, the contractual obligations it had assumed under the LOA that it had given towards IEEE. If we look at the decision, we'll see that the main part of the decision, or the most of the analysis, is focusing on the first angle, on the competition law angle. And that's what we are going also to focus ourselves more here, because the court really saw here more elements to discuss and more elements to give guidance also as well. So here, some clarifications in the beginning when it comes to the front defense as far as a competition law angle has been chosen. The court made clear that the UPC will apply EU law and that it's also bound to the case law of the Court of Justice of the EU, the CJEU, and also the guidance that the CJEU provides if asked by other courts regarding the interpretation of EU law. This was something that was discussed a bit before the UPC started, but here the court made clear that this is the case. So EU law is something that the UPC is bound to, and it's something that the UPC is going to follow. This was, by the way, also the same in the first decision of the UPC by the local division in Mannheim. So there, the court also clarified that EU law is applicable and the guidance of the Court of Justice of the EU applies as well. This means that the negotiation program that the CJEU has established in the Huawei versus ZTE decision back in 2015 is applicable also in the UPC context, and it's not only applicable, it is binding for the UPC. Then here a question was posed, since the UPC is bound to EU law and is also bound to the guidance of the CJEU, whether in the present case it was required to stay the proceedings, to make a pause in the proceedings and seek guidance by the CJEU regarding the implementation of the Huawei ZTE framework. This discussion went back to another development which formally did not really concern these proceedings, but was very much introduced into these proceedings as well, which is an intervention by the European Commission, which generally is unusual in the European context, but nevertheless, it was something that happened in national proceedings in Germany before the Higher District Court of Munich, where the Commission has filed an amicus brief presenting its views on how to interpret the Huawei ZTE framework and how to interpret these negotiation programs and the duties of the parties under this program, and asking the German court in that case to again stay its proceedings and ask the Court of Justice of the EU for guidance. Now, this was introduced in the UPC proceedings as well, and the same request was posed to the UPC, meaning that the court was asked to stay its proceedings and ask the guidance of the CJEU. But both the local division in Mannheim in the previous case, in the first case, in the Panasonic Oppo decision, and the Munich local division saw that there is no need to have this referral. They said that, of course, the Commission's views can be considered, but they are not binding to the courts. And both local divisions did not see any questions posed in the specific case which cannot be solved by the principles, by the balanced principles that the CJEU has developed. So for the time being, although the UPC has clearly said that it's bound to the guidance and the case law of the CJEU, they didn't find any necessity to make a referral to the CJEU on specific questions. Then turning to this negotiation program, the court made a very important clarification here, responding also to a certain extent to some recent developments of the front case law in the UK particularly. The court said here that the negotiation program that the CJEU has developed does not focus only on the determination of license conditions, disregarding the parties' mutual conduct in the negotiations. On the contrary, the court said a purely economic determination of the amount of licensing fees without considering how the parties acted in negotiations would violate mandatory EU law. In this sense, the court fully agreed with the stance that the local division in Mannheim had taken before in the Panasonic Oppo case. Why is this interesting? This is interesting because it gives a view of how the court stands towards the development in the UK particularly, where the courts recently have focused primarily in front cases on the determination of the front terms and conditions of a license, leaving questions of infringement or questions of the party's behavior, of hold up and holdout, etc., in the background. And this is something which the Munich local division, but also the Mannheim local division of the UPC seem to regard differently, and to have a view that this is something that the court needs to do. And apart from that, what the court also clarified here is that exclusionary rights are also basically available for SEPs as well, unless there are exceptional circumstances, of course, which would be the case if we have an abusive behavior. But the court stressed here that the CGU has also made clear that strong protection of IP rights is guaranteed by the IPR Enforcement Directive, and also fundamental rights under the EU Charter of Fundamental Rights. So that this is also something that which the court will consider here. They're not going, the UPC is rather unlikely, based on at least what the decisions say so far, to focus only on the rate determination without looking at the conduct and the behavior of the parties. So we've seen now some general views of the court of how to apply EU law, how to work with the Huawei ZTE framework of the CGU. And now let's turn to the more specific guidance that the court gave regarding the individual obligations or duties under the Huawei ZTE framework. And the first of those is the duty of the patent owner to make a notification of infringement, meaning a duty to inform the implementer that there is infringement and there is a need to take a license before going to court, before filing a lawsuit. Here, there was some debate which originated again from the amicus brief of the European Commission around how this notification should be formally made, and especially the question whether the notification should include all necessary information in one letter, and which was the view of the Commission, or whether you could take a more flexible approach and allow, for example, information to be placed or to allow references to websites or other sources where the information is contained in the letter. So here, the UPC, the Munich local division, agreed with the Mannheim local division again and said that you should not look at this in a very formalistic way. You should, there are no formal requirements on the notification of infringement laid down by the CGU. So you should allow for some more flexibility, because on the contrary, what the court saw here is if you take this very formalistic approach and include very much information in one letter, this can be rather confusing than providing transparency, especially when you have a great numbers of patents in very large portfolios. Then what the court also clarified regarding the notification of infringement is that usually, or in any case, providing claim charts will be sufficient. And this is, in a sense, following existing case law, particularly in Germany, that you can meet your obligation here to make a notification by providing claim charts, mapping the claims of the specific patents to the technical specifications or the parts of the technical specifications of the relevant standard. There was a brief discussion here of whether it is eventually contrary to competition law if you provide a great number of claim charts. Unfortunately, the number that was provided here was not visible because it was redacted in the judgment. But there was apparently an argument saying that if there is a great number of claim charts provided, this could violate competition law. But the court seems not to have much sympathy for that, and it basically disagreed with this argument. So it did not follow that much further. So I think in the end, it is clear that if you provide claim charts, usually the UPC is going to consider that as a sufficient notification of infringement. The next one then is the obligation of the implementer to express willingness to obtain a license on front terms after he has received the notification of infringement. And here there was also a discussion around the amicus brief of the Commission, because what the Commission had suggested there was that this obligation is not to be seen as a very heavy one, that the obligation is discharged usually if the implementer responds and expresses willingness to to sign a license, and not much more should be done from that. If we want to put it in a nutshell, what the Commission believed was the right way to address this obligation. But the UPC here, and this was both the Munich local division and the local division in Mannheim, don't seem to agree with just having any type of declaration being considered sufficient as a declaration of willingness. The quote said here, it should not be mere lip service, but seriously meant. And this means also that just repeating verbatim a wording that has been included in one of the cases does not suffice to say that the implementer is seriously meaningful interested into getting a license. But you need to look at the overall behavior of the implementer. So not only his immediate reaction to the notification of infringement, but how he was involved in negotiations afterwards. Because the quote said here, what is a basic notion under the Huawei ZTE judgment of the CJEU is that parties should be motivated to negotiate in good faith towards agreement, respecting business practice. That was the focus of the CJEU, to support target-oriented negotiations that would lead in a timely manner to the conclusion of an agreement based on the parties' private autonomy, so on the negotiations of the parties. And there, if you take this into consideration, it must also include an assessment of how the parties actually behaved in the negotiations. And this should be also part of the willingness assessment, meaning that, for example, you should also consider a counteroffer that the patent implementer made as an element creating, or let's say showing that there was no willingness. This is the view of the UPC. And what the UPC also said here is that you need to take a look at that on a case-by-case basis, because negotiations are different. There are different stages of the negotiations. The parties sometimes have more information provided, sometimes have less information. So what you need to do is also to look at the individual case and to specify these duties based on the different negotiation stages. And what you also need to do, if you look at the counter offer of the implementer, or eventually also the offer of the patent owner, and want to look at whether this offer has been franked or not, again, you will need to look at the behavior of the parties in the specific case and the specific negotiations. So here, I think the court took the same line as the local division in Mannheim before, by making clear, as we have seen also before, that the behavior counts, and when it comes to the willingness, it's not just a limited analysis of the immediate reaction to notification of infringement, but the overall behavior in every stage of the negotiations should be taken into account on a case-by-case basis. And this is what the courts are asked to do in each individual case. Then the court turned to the SEP owner's offer, the obligation that the patent owner has towards someone who has expressed willingness to take a license in an adequate manner, to make an offer, a written offer on front terms. And here there was some discussion already regarding the requirement to make a written offer. So what does this mean? What is sufficient here and what is not sufficient? There was the argument that this obligation to make a written offer requires basically to produce a document or a draft which is fully formulated, in a sense that it is that you can sign an agreement basically only by accepting the offer and putting your signature at the end. And this was also a little bit the view of the Commission again here. But the Munich local division of the UPC and the Mannheim local division before found that this is not convincing. So it's not really required to have a fully formulated written offer already presented in the beginning, because here the court saw that this is not what happens in real life, basically. So the court found that there is no business practice to start with a draft which is already ready to be signed in every type of negotiations, commercial negotiations, especially when there is no consensus on the key economic aspects. This means vice versa, that it will be usually sufficient if you, for discharging this obligation, to have an offer which includes the key economic framework conditions, which would then allow the implementer to assess the offer and eventually make a counter offer. When there are several offers made, then the question is posed which one to take in order to make your assessment of whether the patent owner has fulfilled its obligation or not. And here there was again a disagreement between the court and the commission, because in its amicus curiae brief, the commission had said that you should assess only the first offer made. So basically giving the patent owner only one chance to get it right. And if this first offer was not perfectly frank, then the rest of the Huawei program should not be taken into consideration. But the Munich local division here said this is not how we understand this obligation. If there are several offers made during the negotiation, relevant is the last offer, the patent owner, which is still open for acceptance, meaning which the implementer can still take and sign. And this is owed to the fact that front is also a process. So this means that there is no abuse of a market dominant position if the first offer is on front, because the first offer is only the starting point of negotiations, which will then lead to developing a front offer. So again, here the court was not convinced by the views of the commission as far as the content or as far as the treatment of several offers is concerned. The question that was posed here very specifically was, however, how to deal in cases where you have multiple options, but you have also to choose, or basically you have two available options, one bilateral offer and one offer for a pool. If you remember, we said already that Huawei had made bilateral offers to Netgear, but had also suggested that Netgear takes a license to the Wi-Fi 6 pool of Sysville, which includes also the portfolio of Huawei. And the question is how to deal with that. What is the difference here? What is the interrelation between the bilateral offers and the offer for the pool license? Especially, is the pool license, can it be considered in this context? Can it play a role and discharge the obligation of the patent owner? And the court said here basically that if you have this constellation where you have two options on the table, a bilateral offer and a pool offer, which can still be accepted by the implementer, and you can assume that at least one of these offers is front and meets the requirements under competition law, then the lawsuit cannot be dismissed. So this means that the offer for a pool license can by itself be sufficient to meet the competition law obligations of the patent owner. Why? Because the court said here what the patent owner is obliged to do, and this is only obliged to do, is to point out the front compliant licensing path, which can be a bilateral license, but it also can be a pool license, which also covers its portfolio. So if the patent owner also shows this potential way to take a pool license, and you can assume that the pool license is front, then this is sufficient. And not only that, if you can assume that the pool offer is front, then you don't need to look at the bilateral offer of the patent owner and see whether it has been found or not, because this would suffice basically to discharge these obligations under Huawei ZTE. So this was here an interesting finding of the court regarding the interplay in cases where you have both bilateral and pool license options on the table. Then the court turned to the last part of the Huawei ZTE judgment, which is the obligation of the implementer who does not accept the offer of the patent owner to make a counteroffer, and if this counteroffer is rejected, to provide security and also to provide information about the use of the patent so far. This has been something which has not been so much in the focus, especially the obligation to provide security and information has not been very much in the focus of the case law so far. But the Munich local division seems to place some weight on that. And this is interesting to see what the reason is for that, or what the thinking of the court is behind that. So the court basically said here, this duty to provide security if your counteroffer has been rejected, and also to provide information, is something that you need to do. And you need to do that irrespective of whether the offer that you received as an implementer by the patent owner has been found or not. This is an obligation that you must fulfill if there is no license signed before the court would start to assess the frank conformity of the patent owner's offer. So what the Munich local division suggests here is that the court will first look at if there was an offer that was rejected and the counteroffer was rejected. It's going to first look at whether there has been sufficient adequate security provided before looking at whether the offer that the patent owner has made was found or not. And in this respect, we had a disagreement between the local division in Munich and the local division in Mannheim, including also a disagreement with the views of the Commission in the amicus curiae brief. Because also the local division in Mannheim seems to suggest that an assessment of the patent owner's offer before looking at the counteroffer and the rest of the duties of the implementer must be done in order not to basically reach a decision without looking at the offer of the patent owner at all. But here the Munich local division takes a slightly different stance and says that I will look at the offer and do all of these additional tasks only if there is sufficient security placed by the implementer, because otherwise he would not have fulfilled its obligations, so he can basically not raise a front defense. And there, of course, if you take this stance, there are some questions that are posed. The most obvious one, what should be the right amount that these security payments should be? And here the court said that the amount of security must at least correspond to the counteroffer. So you should provide security at least to the amount that you have counteroffered to the patent owner. There was another question that is posed here, of course, whether it would make sense to take the usually higher offer of the patent owner as the basis for calculating the amount of security, but the court did not answer that at all here. So it did not say yes, it did not say no. It left the question open because at the end of the day there was no security placed here, so this question did not arise in the proceedings. But what is interesting, I think, is a further element which the court added, which you cannot derive directly from the CJEU decision in Huawei ZTE, which is that apart from providing the money, apart from placing security, the implementer must also make a binding declaration that the patent owner will receive the security amount as royalty if the court examines and confirms that the offer of the patent owner has been found, and there is a final decision confirming infringement. So it's not just placing this amount of security, but she also need to commit that this money will be transferred to the patent owner if the court finds later on that he had acted in a front manner and there is infringement indeed of a patent. So this seems to be rather a new view here, which has some similarities with some developments in Germany in the national courts. But on the UPC level, it is a rather new idea that that the Munich local division has created here. So here, what happens if you look at if you apply all of these principles to the behavior of Netgear? The court found that the front defense cannot be granted. On the contrary, it needs to be dismissed here. On the one hand, the court found that Huawei had met its obligations under the Huawei ZTE framework. There was a sufficient notification of infringement. The court assumed that the offers of Huawei were front, and also it assumed that by making the pool offer, Huawei had met its obligations because Netgear did not really contest that the pool offer of the Wi-Fi 6 SysVal pool had not been front. So there were several reasons for saying that Huawei had met its obligations. And on the other hand, as we're going to see in a moment, the court found that Netgear had failed to meet its front obligations under the Huawei ZTE framework. But what is interesting here is that the court dismissed this front defense as far as it was based on competition law considerations already one step before going into the actual duties and the actual obligations, by saying that Netgear had failed to establish here that the patent in suit confers Huawei a market dominant position. So the front defense, as far as it was based on the competition law, it failed here already since Huawei was not seen to have a market dominant position based on the pleadings of Netgear. And why is that? Mainly because Netgear had questioned that the standard requirements to which the patent in suit referred here are mandatory. So what the court did then was to assume that the standard, at least the specifications that were relevant here, do not set mandatory requirements, which means that there can be no abuse of, there can be no dominant position, because there are other ways to use the standard without using the teachings of the patent in suit here. So since there are alternatives, the idea is to say that you cannot have a dominant position, since you cannot block the implementation of the standard by enforcing the claims here, since it's only, it's not a mandatory option, it's not a mandatory requirement. And this, we're going to see in a moment, played a role also further on in the decision of the court. This argument of Netgear here that the standard requirements relevant here were not mandatory. But definitely what it caused here was the court to even question that there was a market dominant position. So the rest of the analysis was not really compelling here or relevant. Nevertheless, as I said already, the court also saw that Netgear did not fulfill its obligations. And what was interesting particularly here was that the court focused on the lack of a security payment on the side of Netgear, and also on the lack of information that Netgear should have provided. What Netgear, for example, did not do is to provide actual figures of use of the patent in the past, but just provided generally available figures here, which the court found that was not sufficient. So here, looking at the obligations of Netgear, the court focused a lot on the security issue and found that this was the decisive element, more or less, here, that the Netgear had failed to provide security. And that's an interesting takeaway here. There are other elements where the court had also some question marks, especially whether the declaration of willingness was sufficient, or whether Netgear had sufficiently argued against the front conformity of the offer, especially the pool offer. But it seems that the most important element which the court considered was the fact that there was no security placed. So this was the front defense as far as the competition law is concerned. And then we said that there was a second element here, the contractual part. And here the question was whether Huawei had failed to fulfill its contractual obligations under the IEEE LOA that it had granted. So we have seen one element of this already in the beginning of the presentation, where we had the discussion whether the IEEE LOA would prevent Huawei to seek an injunction at all. So the court had denied that. But here we had a different argument again, saying that an injunction should not be granted because Huawei was in violation of its contractual duties this time, not competition law duties, but its contractual duties under the IEEE LOA. So the court looked at that and started to analyze what are exactly what is the contract and what are the contractual obligations that are derived from the IEEE LOA. It said basically that this LOA, it forms a contract for the benefit of the third party under the law of the state of New York, which is applicable here, which means that it is a contract entered into between the patent owner and the standardization body, between Huawei and IEEE in the present case, and which gives rights to third parties, particularly here the implementers of the standard. So this was something that the court accepted and said this is how the contract works, how this IEEE works, IEEE LOA works. And what does it do? Actually, it gives the implementer a contractual claim to be granted a global royalty-bearing license on front terms for standard essential patent claims. Of course, if you look at it vice versa, this means that it creates a contractual obligation of the one who has made the LOA to grant a license, a global royalty-bearing license on front terms for standard essential patents claims, for standard essential patent claims. So this is the content of the obligation, the contractual obligation as the court has interpreted it here. So the question was, did Huawei violate this contractual obligation? And here, again, the argument that Netgear had raised, basically arguing that the relevant standard specifications here are not mandatory, played a central role in the decision of the court, because the court said, if you look at Netgear's pleadings, you have an irresolvable argumentative contradiction. Why? Because on the one hand, Netgear is arguing that the standard specification is not mandatory, meaning that you can use a standard even without using the specific patent. And on the other hand, they are saying that Huawei violated its obligation to grant a license for standard essential patent claims, although they have been arguing that these patent claims are not actually standard essential. So here, that meant in the eyes of the court that this obligation did not arise here, because we are not talking about standard essential patent claims if we argue that the standard specifications are not mandatory, which means that this contractual obligation did not arise at all and it could not be violated. And apart from that, very basic analysis here, the court also saw that Netgear did not plead any additional elements that could support its view. For example, it did not plead that the pool offer did not suffice to discharge Huawei's duties under the IEEE LOA, or it did not argue that the conditions of the pool license were discriminatory. So these were also some additional elements, but the main argument here for dismissing the front defense as far as it was based on contractual considerations was again this argument that the patent claims were actually not mandatory and therefore are not standard essential in terms of the IEEE LOA. So this was then the front defense, and to finally, one last element here, the proportionality, which I mentioned before. So this was something on top, more or less, of the front arguments on the front defense, which is an argument saying that you should not grant an injunction based on the infringement of the specific patent because you would create damages or you would create distress to the implementer, which goes far above the or beyond the actual value of the technology that's being incorporated in the patent. So this is an argument that was raised here as well, to say that the injunction should not be given because, if we want to put it very simple, it causes disproportionate harm, which is in no relation to the actual value of the one patent or the technology that the one patent incorporates. Now, the court generally was very, very cautious to hear these arguments because it said proportionality aspects were already comprehensively considered in the context of the front defense, both from the competition law perspective, but also from the contractual perspective. So here, on putting on top of the front defense and all of the aspects that have been assessed and examined there, also this additional element of proportionality was not considered to be very sound here by the court, which also argued here that Netgear did not provide any additional elements that could maybe force the court to look at proportionality on top of the front defense as well here. The court said, on the contrary, again, Netgear argued that the standards requirements are not mandatory, which of course weakens very much any argument on proportionality, because again, if the harm that would be caused by an injunction would be relatively acceptable if you could still use the standards by not using, even if you don't use the patent in suit. And finally, one final comment here of the court regarding proportionality is that this argument could also not be very strong if you consider that Netgear has still the possibility to sign a pool license at any time. So if you have the possibility to legitimize the use of the patent by taking a pool license and avoid any harm caused by an injunction, then these proportionality arguments seem to be much, much weaker. So that was all from the court here, the most important aspects of this decision, which I think is an interesting one and gives some indication, again, if we look at this in conjunction with the first case of how the UPC wants to deal with front cases. I think a first conclusion is that looking at the behavior of the parties and the conduct will remain important in the UPC. The UPC is very unlikely to focus only on front determinations as the UK courts have done. And if we look at this judgment specifically here, what is interesting and something definitely to look at is how this focus on the security payment will evolve in the case law and how much weight it's going to get, because the court has already made some findings here or have presented some ideas that could change the importance of this factor in case law, in the case law of the UPC going forward.